Now, attorneys for Vibes Cartel are warning the courts. They are warning the courts that if their clients are not released, then there will be challenges, more challenges, major issues, legal issues for the crown, for the state, if their client is not released. I'm like them legal talk there. But again, when you have your hand in the lion's mouth, may I ask you if you please take it out. You hear me? When you have your hand in the lion's mouth, I am telling you if you please take it out. The attorney for Vibes Cartel and co-accused one of more legal challenges amid major issues to be faced if they are not free. Issa Buchanan, the attorney represented Entertainment Vibes Cartel, real name Adija Azim Palmer, on Wednesday declared that the matter will be back before the courts of appeal if a retrial is reordered. Then I saw him feel cockety, or him know something that we don't know. Issa Buchanan, with admissible still a live issue for the one set the case against his client, co-accuser. If a retrial is ordered, defense will appeal any decision made by the trial court to use evidence the defense maintain is inadmissible based on breaches in the original trial 13 years ago. So the prosecution case was that the correspondent and the communication media taken as a whole with the evidence of the sole witness provided the fact of killing, the reason for the killing, the method of disposal of the body, and the identity at least one of the killers, namely Palmer. The defense had argued that the evidence was obtained in a breach of constitutional rights of the men and was therefore inadmissible. That them a go use. Imagine. The Privy Council in March quashed the murder conviction, placed the questions of a retrial back on the lap of the Jamaican court. Wednesday, Buchanan, in addressing the appeal court panel of the Justice Marva McDonald, Bishop Paulette Williams, and David Fraser, said if the courts were to decide there is to be a retrial, a judge will be conducted a a trial within a trial, at best to determine the admissible of the technological evidence. It's going to be challenged if we are to go back. So note can be made right here that in any event we are submitting, there will be an appeal to the courts if it turns out not in our favor. Imagine. So what you now say? What Issa say really uno are go continue to run to the Privy Council? Uno are go do everything? We are ready, he says. We have guidance in the jurisdiction that the starting point of Constitution is the government must justify a breach. So there has to be some consideration. However it ends. The problem now is that the prosecution, in terms of the strength of the case, have two planks: a sole witness and technological evidence, Buchanan said. In noting that the prosecution will be relying on video evidence of the murder taking place, Buchanan told the panel in any event, if it is admissible, the strength of the prosecution case is whittling down by the evidence as was a breach of previous trial. Once the court make a determination, are hurdles the prosecution must overcome, which involve the challenges to the technological evidence, he said, in declaring that the defense will bring witness to establish that the phone evidence and the technological evidence put Crown's case in the worst position. When asked by Justice McDonald Bishop what the implication of the defiance in the court by the Crown, Buchanan said if the case was sent back for retrial, the prosecution will be given a chance to fix some of the holes in the case. It's not in the interest of justice to send it back because the prosecution would have the opportunity to fix some of the evidence. They are fixable. It would be the second bite of the cherry, Buchanan said, as he added, the key challenge to the defense was the death of the handwriting expert who had appeared in the original trial. It is a major loss, and in fact, the music of the defense bar would not be melodic if this witness is not available, he added. As to the mentality and the physical health of Palmer, the attorney said that his client, who has been diagnosed with grave disease, is withering away with a 50% chance reduction in his heart function, increasing the possibility that he would not survive a second trial. Therefore, he said, Palmer, who has had a foot that cost for his treatment by private specialists, has been unable to earn during incarceration and is financially depleted, having also had to pay the bills of his co-accused for legal representation, which amounts to millions. Wednesday attorney John Clark, who is the lead attorney representing Jones and St. John's, in capping the submission made by the defense team, argued that the Crown was attempting to repair the proverbial Humpty Dumpty in pushing for Palmer and his co-accused to be retried. In another justice jurisdiction, new trial orders have expired date. In our jurisdiction, there's no procedural safeguard of a statutory expiration date for a new trial order. We submit that when some of the constitutional rights are in breach at some point in time, fairness would demand that a line be drawn in the sand to ensure that lapse of time or delay is a sufficient factor to some malignate against making of any order of a new trial, Clark said. The integrity of the trial was affected when the eggs fell to the ground and ultimately became broken. Because of that, no direction from the judge or jury could cure that mischief. So we could put that trial together and continue with the trial. No. Now the question is, if Humpty Dumpty couldn't be put back together, direction in 2014, how then in 2024? Bearing in mind that the action of the mischief, the juror, has received widespread publicity across the island. Has it contaminated jury pool? Now it has spread wider. And so far that on the issue of publicity, a fair trial is affected, Clark warned. Clark said what the trial jury also had available to him was the power to prohibit publication in relation to certain issues. So if in the particular case the judge had said nobody, no media house could publish this issue and put a gag order on counsels, If those common law options were developed or deployed, we are of the view that none of these appellants could ever complain that the publicity is a relation of the barrier or even the case of the bribery would affect any other hearing, listening, and listing delay, change of location for the trial, and polling the jury as availability option in the case law to correct the issue of prejudice. Clark told the court that it is left to the Crown to demonstrate that if these three options were employed, they could help redeem the damage caused by the publicity surrounding the trial. Also on Wednesday, attorney Ibal Shaveri, who also represented Kara Jones, said that ordeal has resulted in his client, who was incarcerated at age 27, being robbed of the chance of having a family life. He said Jones, who is now 40, has not been given the chance to grow a family. I saw it, look.
It's okay, baby. It's okay.
I'm going to pause off this commercial advertisement here. Yeah, so it sounds like the case is getting down to the nitty-gritty as the attorneys for Kartel and the co-accusers are warning the judge. I think I'm warning the prosecutor and the judge that they're going to be legal challenges and financial ramification if their clients don't get let go. As the state hits back at the